My name is Vivian Achebe-Laurent. I am a United States District Judge for the Eastern District of Virginia. You need to verify that immediately.
Oh, I know exactly what name is on this address. And I don't care what title you think protects you. We have intelligence tying this house to suspicious foreign activity.
At 6:12 a.m. on Sunday, March 1st, 2026, the smell of pancakes filled a narrow Alexandria townhouse 3 blocks from the Potomac. Judge Vivian Achebe-Laurent stood at the stove in a cotton robe, flipping batter while her 7-year-old son Solomon sat cross-legged on the couch watching cartoons with the volume too loud. Upstairs, her 11-year-old daughter Nadia was already dressed for church, arguing through the bathroom door that Solomon had taken her hairbrush again. It was the kind of morning that didn't make the news. Quiet, ordinary, warm. Vivian was 44 years old, Harvard Law, top of her class. She had spent 6 years as a federal prosecutor at the Department of Justice before being nominated to the U.S. District Court for the Eastern District of Virginia. Senate confirmed 4 years ago with bipartisan support. She carried an active caseload that included 2 national security matters and a high-profile civil rights case that had drawn attention from Washington and beyond. She was disciplined, private, and careful with every word she spoke on and off the bench. That morning, her church dress hung on the back of her bedroom door. Solomon's clip-on tie sat on the kitchen counter next to a sippy cup he swore he didn't use anymore. Nadia's Bible study notebook was open on the dining table, a colored pencil still wedged in the spine. Vivian had no idea that in less than 30 minutes, the front door of her home would be blown off its hinges, that federal agents in tactical gear would pour into her kitchen, that her son would be dragged off that couch and put face down on the floor, that her daughter would be grabbed by the arm at the top of those stairs, and that everything about this morning, every quiet, ordinary detail, would become evidence in one of the most devastating federal civil rights cases in modern American history. 6 weeks earlier, on a Tuesday afternoon in January, FBI counterintelligence analyst Craig Stenner sat at his desk inside the J. Edgar Hoover building in Washington, scrolling through the Bureau's online tip portal. Stenner was 36, competent enough on paper, but known among colleagues as someone who chased volume over accuracy. He flagged more tips than anyone in his unit. Most went nowhere. He didn't seem to mind. At 2:17 p.m., a submission caught his eye. It alleged that a woman living at 814 Braddock Lane in Alexandria, Virginia, had been making wire transfers to financial entities with suspected ties to Iranian intelligence. The tip included a name, Vivian Achebe-Laurent, a partial physical description listed as black female, early 40s, and a claim that she had been photographed at a restaurant in Georgetown with a known Iranian diplomatic attaché. There was no supporting documentation, no account numbers, no surveillance imagery, no name attached to the person submitting the tip. It had come through an anonymous portal entry routed through a burner email. Stenner flagged it and forwarded it to his supervisor, Special Agent in Charge Brent Kirkwood. Kirkwood was 52, a career bureau man with a reputation for aggressive case development and a deep interest in counterintelligence headlines. He read the tip once, asked no follow-up questions, and approved it for preliminary investigation the same afternoon. No one ran Vivian's name through the federal judiciary employee database. No one checked whether she held a government position. No one cross-referenced her address with any law enforcement or intelligence personnel records. The tip was vague, uncorroborated, and anonymous. It should have been flagged for further vetting at minimum, or dismissed outright. Instead, Kirkwood told his team to move fast. He called it a potential high-value lead, and from that moment on, every decision that followed was built on a foundation that no one in the Bureau had bothered to verify. Over the next 6 weeks, every safeguard that should have caught the mistake failed. Not one of them held. Stenner built the case file the way he built most of his cases: fast, surface level, and with just enough material to look thorough without actually being thorough. He pulled Vivian's financial records through a parallel channel typically reserved for FISA-adjacent national security requests, a move that bypassed the more rigorous internal review process. What he found should have told him everything he needed to know. Vivian had made recurring donations to a legal aid nonprofit that served immigrant communities, including clients from the Middle East. The transactions were modest, documented, and tax-deductible. Stenner flagged them as suspect wire transfers to entities with foreign ties. He never contacted the nonprofit, never checked its tax status, never noted that it had been operating legally in Virginia for over a decade. Then came the photograph. During a 2024 legal conference in Washington hosted by the American Bar Association, Vivian had posed in a group photo with more than a dozen attendees. One of them happened to be a mid-level Iranian diplomatic attaché who had been invited to a panel on international law. Vivian hadn't spoken to him individually. She didn't know his name. But the photo made it into the file, captioned as evidence of a potential clandestine relationship. A junior analyst in the unit, Priya Venkatesh, 29, raised concerns in a written memo. She pointed out that the financial records didn't support the conclusion being drawn, that the tip was anonymous and uncorroborated, and that no one had verified the subject's employment or government affiliation. Kirkwood read the memo, called her into his office, and told her to stay in her lane. 2 days later, her objections were removed from the case file entirely. Kirkwood told his team this could be a big one, and no one left in the room was willing to tell him he was wrong. The warrant application landed on the desk of a federal magistrate judge in the Eastern District of Virginia on February 26, 2026. The affidavit was 12 pages long and built almost entirely on 3 pillars: the anonymous tip, the mischaracterized financial records, and the conference photograph. Each piece of evidence had been framed to suggest something it did not actually prove. The charitable donations became suspect international transfers. The group photo became a documented meeting with a foreign intelligence-linked operative. The anonymous tip became a credible source with knowledge of the subject's activities. What the affidavit did not include was any mention of Vivian Achebe Laurent's occupation. It did not state that she was a sitting United States District Judge. It did not note her prior service as a Department of Justice prosecutor. It did not reference her Senate confirmation, her security clearances, or her active national security caseload. The magistrate judge reviewed the affidavit, asked no clarifying questions, and signed the warrant that same afternoon. Kirkwood moved immediately. He assembled a full tactical entry team of 14 agents, body armor, sidearms drawn, flashbang grenades authorized. The raid was scheduled for 6:45 a.m. on Sunday, March 1st, a time specifically chosen because the subject would be home and, in Kirkwood's words, less likely to have outside support present. No one on the team suggested a less invasive approach. No one proposed a simple knock on the door. No one recommended calling her attorney or serving the warrant through the court. 14 agents, full tactical gear, drawn weapons, a battering ram, and a federal judge making pancakes for her children on the other side of the door. The operation was approved without a single voice asking whether any of it was proportionate. At 6:44 a.m., 1 minute ahead of schedule, the battering ram hit the front door of 814 Braddock Lane. The lock shattered on the first strike. The door frame splintered inward, sending wood and metal across the entryway floor. 2 flashbang grenades followed, one into the living room, one toward the kitchen. The concussive blasts shook the walls. Solomon, who had been lying on the couch watching cartoons with a blanket pulled to his chin, screamed. An agent in full tactical gear reached him in 3 steps, pulled him off the cushions by his arm, and forced him face down onto the hardwood floor. He was 7 years old. In the kitchen, Vivian spun toward the sound just as 2 agents came through the doorway. One grabbed her by the shoulder and drove her sideways into the counter. Her face struck the granite edge. The impact split the skin above her left eye. Blood ran down her cheek before she hit the floor. She was forced onto her stomach, arms wrenched behind her back, wrists locked into handcuffs. She could hear Solomon crying from the living room. She could hear boots on the stairs. "I am a federal judge," she said. Her voice was loud and clear despite the blood and the pressure on her spine. The agent kneeling on her back didn't pause. "Sure you are," he said. Upstairs, Nadia heard the explosions and the screaming and came running down the staircase in her church dress, shoes untied, eyes wide. An agent intercepted her halfway down, grabbed her by the upper arm, and brought her to the floor beside her brother. She was 11. She landed on her knees and then her chest, her face pressed to the same hardwood where Solomon lay sobbing. Both children were now on the ground, surrounded by armed men in black helmets, in their own home, on a Sunday morning. Vivian lay on the kitchen tile with her cheek against the cold floor, blood pooling beneath the cut above her eye, her wrists locked behind her back at an angle that sent pain through both shoulders. Her breathing was controlled. Her voice, when she spoke again, was steady and precise. "My name is Vivian Achebe Laurent. I am a United States District Judge for the Eastern District of Virginia. My judicial credentials and identification are in my study. Second door on the left, top drawer. You are making a catastrophic mistake." The lead entry agent, Supervisory Special Agent Russ Pennington, 45, stood over her. For the first time since the breach, he did not move immediately. Something in her tone, in the specificity of her words, in the calm that no ordinary person under duress could manufacture, made him pause. He keyed his radio. "Command, the subject is claiming to be a federal judge, requesting guidance." The response came from Kirkwood, sitting in a black SUV parked 2 houses down, monitoring the operation on a tablet. "Continue the search. She can sort it out downtown." Pennington hesitated for half a second longer, then gave the order. Agents moved through every room. Books were pulled off shelves and thrown to the floor. Drawers were dumped. Closets were emptied. They seized both of Vivian's laptops, her personal phone, an external hard drive containing case research, her children's school tablets, and 3 family photo albums. In the living room, Solomon had stopped crying and gone silent, his small body trembling, a dark stain spreading across the front of his pajama pants. He had wet himself. Beside him, Nadia lay with her eyes open and her chest heaving in short, shallow gasps, unable to slow her breathing, unable to speak. A federal judge's children, face down on their own floor, surrounded by agents who still had not verified who their mother was. And in the SUV outside, Kirkwood checked his watch and typed a message to headquarters. "Raid executed. Subject secured. Proceeding with evidence collection." The noise carried. In a neighborhood like this one, where the houses sat close and the streets stayed quiet on Sunday mornings, the sound of a door being broken open and flashbang grenades detonating was impossible to miss. Frank Oberlin was the first one outside. He was 68, retired Army colonel, lived in the townhouse directly next door, and had known Vivian for 3 years. He had watched her carry groceries inside on weeknights, had waved to her children when they played on the front steps, had attended the same neighborhood association meetings where she sat quietly in the back row, always polite, always composed. When he stepped onto his porch and saw the black SUVs, the tactical gear, and the agents moving in and out of Vivian's front door, he walked straight to the perimeter tape. "That's a federal judge's home," he told the agent guarding the line. "Her name is Vivian Achebe Laurent. She sits on the Eastern District bench." The agent didn't blink. "Sir, step back or you'll be detained." Oberlin didn't move. "You're making a mistake. I'm telling you who lives in that house. Step back. Now." Oberlin pulled out his phone and began recording. Across the street, Terrence and Simone Osei had come to their front window when the first blast shook the block. Terrence grabbed his phone and started filming from the doorway. The footage was shaky, but clear. Agents in full tactical gear, a broken front door, and then, at 7:03 a.m., the image that would later be seen by millions. Vivian Achebe Laurent, in a cotton robe and church slippers, blood visible on the left side of her face, hands cuffed behind her back, being walked down her own front steps by 2 agents, while a neighbor's child watched from a second-floor window across the street. Within minutes, the footage was in a neighborhood group chat. Within an hour, a local journalist had it in her inbox. Within 2 hours, it had already been shared more times than anyone in that neighborhood could have predicted. And not a single agent on the scene had yet confirmed who they had just raided. At the FBI's Washington field office, Vivian was placed in an interrogation room on the 3rd floor. The handcuffs stayed on. The cut above her eye had not been treated. Blood had dried in a thin line down her left cheek and along her jaw. She sat upright in a metal chair, still wearing her robe and slippers, and said nothing. She did not ask for water. She did not ask where her children were. She asked for one thing. I want my attorney. I will not answer questions without counsel present. I am a sitting United States District Judge. You can verify this in less than 60 seconds. The two agents in the room exchanged a glance. One left. The other stayed by the door, arms folded, silent. Vivienne sat still. For nearly 2 hours, no one verified her identity. No one ran her name through the federal judiciary database. No one contacted the Eastern District Clerk's office, which operated a 24-hour duty line specifically for emergencies involving judicial personnel. At 9:14 a.m., more than 2 hours after the raid, a junior agent who had not been part of the entry team typed Vivienne's full name into the federal court's personnel system. The result appeared in under 4 seconds. Achebe Laurent, Vivienne R. Title: United States District Judge. Court: Eastern District of Virginia. Status: active. Appointed by the President. Confirmed by the Senate. The agent stared at the screen, pushed back from his desk, and walked quickly down the hall. He found Kirkwood in a briefing room reviewing evidence logs. Sir, the subject is a federal judge. Kirkwood looked up. What? She's a sitting U.S. District Judge. Eastern District of Virginia. Senate confirmed. Active bench. The room went quiet. Every agent in it understood in the same instant what had just happened and what was about to come. Kirkwood set down the file he was holding. His face lost its color. Down the hall, in the interrogation room, Vivienne sat exactly as she had for the last 2 hours. Bleeding. Calm. Waiting. And somewhere on the 3rd floor, someone finally thought to ask the question that should have been asked 6 weeks ago. Did anyone check who she actually is? While Vivienne sat in that interrogation room for 2 hours, waiting for someone to confirm what she had told them from the moment they broke down her door, her children were in a separate room on a different floor of the same building. Solomon and Nadia had been transported in the back of an unmarked federal vehicle. No car seats, no seatbelts fitted for a child Solomon's size. No explanation of where they were going or why. Solomon had not spoken since the agents put him on the floor of his own living room. He sat in a plastic chair with his knees pulled to his chest, still in the pajamas he had wet during the raid, the fabric now cold against his skin. No one had offered to change him. No one had offered him clothes or a blanket or food. He was 7. Nadia sat beside him, rigid, staring at the wall across the room. She had stopped hyperventilating in the vehicle, but had not spoken a full sentence since being pulled to the ground on the staircase. When a victim's advocate was finally brought in, more than 90 minutes after the children arrived, she found them sitting in silence in a room with no windows, no toys, no crayons, nothing that acknowledged they were children. The advocate, a woman in her 50s who had worked with the Bureau for over a decade, later told investigators it was one of the worst things she had seen in her career. A child psychologist brought in that afternoon conducted preliminary evaluations on both children. Solomon exhibited signs of acute stress response, including trembling, selective mutism, and a flinch reaction triggered by any sudden movement or loud sound. Nadia presented with emotional shutdown, flat affect, and what the psychologist described as hypervigilant stillness, a trauma response more commonly associated with children in war zones. Vivienne was not allowed to see her children until 9:47 a.m., nearly 3 full hours after they had been separated. When she finally entered the room, still in handcuffs that had only just been removed, Solomon looked up at her and said one word. Mama. It was the first thing he had said in over 3 hours. By 10 a.m. on March 1st, the machinery of institutional panic had begun to move. The first call went from the FBI's Washington field office to the Chief Judge of the Eastern District of Virginia. The conversation lasted less than 2 minutes. The Chief Judge's response, according to sources briefed on the call, was a single question, repeated 3 times. You did what? By 10:15, the Administrative Office of the U.S. Courts had been notified. By 10:30, 2 United States senators with oversight of the Judiciary Committee had received calls from their staff flagging an incident involving a sitting federal judge. By 10:45, The FBI Director's Office was alerted through an internal channels memo marked Urgent, a classification rarely used outside of active threat scenarios. Kirkwood was pulled from the case before noon. He was told to return to the field office and not to contact any member of the investigative team. Stenner, the analyst who had flagged the original tip and built the case file without ever verifying the subject's identity, was placed on administrative leave effective immediately. His access to classified systems was suspended. Supervisory Special Agent Russ Pennington, who had led the tactical entry, was reassigned to administrative duties pending review. The DOJ Office of Professional Responsibility opened an emergency inquiry before the end of the day. Behind closed doors at the Hoover Building, the damage assessment was already underway. A deputy director convened an emergency meeting with senior leadership from counterintelligence, legal counsel, and the inspection division. The question he asked the room, according to two officials present, was direct. How did we raid the home of a sitting federal judge, put her face down on her kitchen floor, hold her children in a windowless room for 3 hours, and not one person in this building knew who she was? No one answered immediately. The silence in that room carried the weight of what everyone already understood. This had not been a failure of technology or access. The databases existed. The information was there. No one had looked because no one had thought to look. A black woman with an African surname living in a nice neighborhood had matched someone's idea of a threat, and from that point forward, every system designed to prevent exactly this kind of catastrophe had been bypassed, ignored, or overridden. And now the entire Bureau was going to answer for it. The neighbor footage reached social media before the FBI had even confirmed Vivian's identity. Terrence Osei's video was 43 seconds long. Shaky, slightly overexposed in the early morning light, but unmistakable. A black woman in a cotton robe and church slippers, blood on her face, hands cuffed behind her back, being walked down the steps of her own home by 2 agents in tactical gear. Behind her, through the broken front door, the audio captured a child screaming. The video hit a neighborhood group chat at 7:11 a.m. By 7:40, a local journalist had it. By 9 o'clock, a Washington reporter confirmed through court records that the woman was a sitting United States District Judge. The story detonated. Every major outlet ran some version of the same headline. FBI raids home of black federal judge. The footage played on loop across cable news and social media. Legal analysts called it unprecedented. The National Bar Association issued a statement calling the raid one of the most egregious violations of judicial independence and civil rights in modern American history. The NAACP demanded a full independent investigation. By evening, 14 sitting federal judges had signed a rare joint statement expressing profound concern over the treatment of their colleague. 2 members of Congress called for emergency oversight hearings. A constitutional law professor at Georgetown told a reporter she had never seen anything like it in 30 years of studying federal law enforcement. And in a windowless room at the Washington field office, the 2 children at the center of it all still had not been given a change of clothes. In the days that followed, the institutional rot beneath the raid began to surface. Investigative journalists filed records requests on Kirkwood's counterintelligence unit. What emerged was a pattern stretching back nearly a decade. Of 41 investigations opened by his team over 8 years, 29 had targeted individuals who were Black, Middle Eastern, or South Asian. More than half were initiated on anonymous or thinly sourced tips. Fewer than a third produced anything actionable. None led to a prosecution. Kirkwood's unit had operated under national security classification that shielded it from routine oversight. Internal review mechanisms deferred to his judgment. The result was a team with minimal accountability and a supervisor who treated aggression as ambition. Priya Venkatesh, the junior analyst who had flagged concerns 6 weeks before the raid, cooperated with the DOJ Office of Professional Responsibility. Her written memo questioning the case's evidentiary basis had been removed from the file before the warrant application reached the magistrate. Kirkwood had told her to stay in her lane. She had kept a personal copy. She turned it over to investigators on March 2nd. Separately, digital forensics teams began tracing the anonymous tip. The submission had come through a burner email created the same day, routed through a VPN. But metadata recovered from the portal's backend pointed to someone familiar with federal court procedures. Investigators began quietly exploring a possibility that would transform the case entirely: that the tip had been fabricated by someone connected to one of Vivian's active rulings. If confirmed, it would mean the FBI hadn't just failed to vet the evidence, it had been weaponized. As of March 2, 2026, Vivienne Achebe-Laurent has not spoken publicly. Not a single word to the press, no interviews, no statements on camera. Her attorney, former federal prosecutor Camille St. Pierre, issued a brief written statement on her behalf that afternoon. It confirmed that a federal civil rights lawsuit was being prepared. It requested the immediate preservation of all body camera footage, tactical communications, surveillance recordings, internal emails, and case files related to the investigation. It stated that both children were being evaluated by a trauma specialist and that the family was requesting privacy while they began to process what had happened less than 24 hours earlier. The statement was 4 paragraphs long. It said everything it needed to say and nothing more. Legal observers noted that Vivian's silence was not absence, it was strategy. She was a sitting federal judge who understood that every word she spoke publicly would be scrutinized, dissected, and potentially weaponized to paint her as emotional, politically motivated, or unfit for the bench. Her restraint was not weakness. It was the discipline of a woman who had spent her career inside the system and understood exactly how to dismantle its failures from within. Behind the scenes, her legal team had already contacted the DOJ Inspector General, the Judicial Council, and 2 congressional offices with jurisdiction over both the judiciary and federal law enforcement. The machinery was beginning to move, but Vivian had not yet shown her hand, and anyone who knew her understood that when she did, it would not be emotional. It would be precise. As of this moment, nothing is resolved. Kirkwood has been suspended from duty pending investigation. Stenner has retained a private attorney. Supervisory Special Agent Pennington has been reassigned. The magistrate judge who signed the warrant is under review by the Judicial Council for failure to scrutinize the affidavit. The FBI has issued a single, carefully worded statement acknowledging what it called procedural shortcomings in the investigation. It has not apologized. Congress has called for oversight hearings. 2 Senate committees have requested full briefings from the Bureau's director. Vivian's lawsuit, filed in the District of Columbia, names the FBI, Kirkwood, Stenner, Pennington, and 12 unnamed agents. It alleges violations of the Fourth Amendment, racial profiling, excessive force, false imprisonment, and intentional infliction of emotional distress. Nadia and Solomon have been added as plaintiffs. Their claims include trauma, unlawful detention of minors, and denial of basic care while in federal custody. No settlement has been offered. No disciplinary action beyond suspension has been finalized. No criminal charges have been filed against any agent involved. The investigation into the origin of the anonymous tip is ongoing, with digital forensics still tracing the submission through layered VPN routing. If the tip is confirmed to have come from a litigant connected to one of Vivian's cases, the scope of the scandal will expand from negligence into something far more deliberate. But as of today, none of that has been confirmed. None of it has been denied. The front door of 814 Braddock Lane is still broken. The blood has been cleaned from the kitchen counter. Solomon still flinches at loud sounds. Nadia still has not spoken a full sentence to anyone outside her family. And the woman who sat bleeding on her own kitchen floor in handcuffs is still on the bench, still hearing cases, still waiting for the system she serves to answer for what it did. This case was brutal, but the case on the right spirals completely out of control.
You can't just walk in here demanding things like you own the place.
I'm asking to see my children.
Your daughter has marks on her body and you expect us to just ignore it? Families like yours always have an excuse.
What exactly do you mean by that?
I mean, we've seen this before. Defensive, confrontational, acting...
At 11:47 a.m., inside the front office of Maplewood Elementary School, a white principal stood with her back to the hallway, phone pressed to her ear, and said calmly, "Yes, I need an emergency removal. The children are in danger. Two CPS workers were already walking through the front doors, lanyards swinging, clipboards in hand. The black woman standing 6 feet away, watching this unfold, was not who any of them thought she was. Her name was Nadine Coulter. She was a sitting federal judge on the United States District Court, Eastern District, appointed by the President, confirmed by the Senate, and responsible for presiding over the very type of civil rights case that was now playing out in real time against her own family. Her children, Elijah, 10, and Amara, 7, were sitting in a locked classroom down the hall. Amara had been crying for 20 minutes. Elijah had asked 3 times to call his mother. Both requests were denied. Principal Janet Driscoll had made her decision the moment she saw a bruise on a little black girl's knee. She never consulted the school nurse. She never called the mother. She called CPS and requested emergency removal, using words like imminent danger and signs of physical abuse on multiple children. The school security cameras were recording everything, every hallway angle, every office entrance, every frame of what was about to become one of the most explosive civil rights cases in the state's history. Driscoll had no idea what she had just set in motion. Before we continue, comment where in the world you're watching from, and make sure to subscribe because what happens next will leave you speechless. Janet Driscoll had been an educator for 18 years, the last 9 as principal of Maplewood Elementary in the affluent, predominantly white suburb of Lake Ridge. On paper, she was a model administrator, involved, organized, and fiercely protective of what she called the culture of this school. In practice, that protectiveness had a pattern. Over the past 6 years, Driscoll had filed 14 CPS referrals against families at her school. 13 of those families were Black or Hispanic. Not a single referral resulted in a substantiated finding of abuse or neglect. Every case was closed. Every family was cleared. And every time, Driscoll moved on to the next one without consequence. Parents had tried to push back. 3 families filed formal complaints with the school board, describing a principal who scrutinized their children more closely, questioned their home lives more aggressively, and treated normal childhood incidents as evidence of dysfunction. The complaints were reviewed internally and quietly dismissed. Driscoll had connections that insulated her. Her husband, Gary Driscoll, sat on the Lake Ridge City Council. Her sister-in-law, Rita Driscoll, worked as a caseworker in the county CPS office. Between the school board, city hall, and child services, Driscoll operated inside a network that had never once held her accountable. She believed she was the gatekeeper of her community, that her judgment about which families belonged and which didn't was not just valid, but necessary. In an email sent to a colleague 2 years earlier, she had written, "Some families just don't belong in a school like this. It's not about race, it's about standards." That email would later be entered into evidence. But on this Wednesday morning, none of that history mattered to Driscoll. She had found what she believed was her next case. A bruise on a black child's knee, and she was already making the call. Nadine Coulter's path to the federal bench began in the Raymond Rouse housing projects in West Baltimore, where she shared a 2-bedroom apartment with her mother and 3 siblings. Her mother worked double shifts as a hospital custodian and kept a rule in the house that was never negotiable: homework before anything. Nadine earned a full academic scholarship to Howard University, graduated summa cum laude, and was accepted to Yale Law School, where she finished top of her class. She clerked for a Supreme Court justice, spent 6 years as a federal prosecutor specializing in civil rights cases, and at 39 was appointed to the United States District Court for the Eastern District, making her one of the youngest black female federal judges in American history. Now 43, she presided over civil rights and constitutional law cases. She had ruled on police misconduct, housing discrimination, and unlawful government overreach. Her opinions were cited in law reviews. Her reputation on the bench was precise, fair, and unmovable. Her husband, Derek Coulter, was a trauma surgeon at the city's largest hospital. 2 years ago, they moved to the Lake Ridge district specifically for the school ratings. Elijah, their son, was gifted and quiet, reading 2 grade levels ahead. Amara, their daughter, was social and artistic. the kind of child who made friends on the first day and drew pictures for her teachers. Both were model students, no behavioral issues, no academic concerns. Nadine volunteered at school events, attended every parent-teacher conference, and donated to the annual fundraiser. Despite all of this, from the very first week, she felt the resistance. Driscoll's greetings were colder to her than to other parents. Her children's behavior was scrutinized more closely. Minor incidents that were laughed off for white students were flagged and documented for hers. At one conference, Driscoll asked Nadine about her home environment 3 separate times. Nadine noticed. She always noticed. She just never imagined how far it would go. That Wednesday morning started like any other. Nadine pulled into the Maplewood Elementary drop-off lane at 7:45 a.m., kissed both children goodbye, and watched them walk through the front doors. Amara wore a navy skirt and a yellow top, her backpack bouncing with each step. On her left knee was a small bruise, greenish-purple around the edges, from falling off her bicycle in the driveway 2 days earlier. Derek had cleaned it, put a bandage on it, and by Monday morning, Amara had forgotten about it entirely. A teacher noticed the bruise during morning circle and, following school protocol, reported it to the principal's office. Protocol required documentation and, if warranted, a call to the parent. Driscoll skipped the call. Instead, she pulled Amara out of class and brought her to the principal's office alone. No parent notification, no school counselor present, no nurse consulted. For nearly 20 minutes, Driscoll questioned a 7-year-old girl behind a closed door. The questions were leading, repetitive, and designed to produce a specific answer. Does mommy or daddy ever hurt you? Do they hit you when you're bad? Are you scared at home? Has anyone told you not to tell? Amara said no each time. She said it clearly. She said it repeatedly. And each time, Driscoll pressed harder. The hallway security camera captured Amara being led into the office with a confused expression and Driscoll closing the door behind them. 20 minutes later, it captured Amara leaving in tears. Driscoll then had Elijah pulled from his 4th grade classroom. Same office, same closed door, same questions. Elijah, more composed than his sister but visibly uncomfortable, answered no to every question and then asked, "Can you call my mom?" Driscoll looked at him and said, "That's not necessary right now." She had already decided what she was going to do. And calling the mother was never part of her plan. At 10:15 a.m., with both children back in their classrooms, still shaken from the interrogation, Driscoll sat in her office and picked up the phone. She did not call Nadine Coulter. She did not walk down the hall to consult the school nurse, Karen Whitley, who would later confirm under oath that the bruise on Amara's knee was entirely consistent with a minor fall, and that no one from the principal's office ever asked her to examine it. She did not consult the school counselor. She did not review Amara's or Elijah's files, which contained no behavioral flags, no prior concerns, and no history of anything other than 2 well-adjusted children excelling in their classes. Instead, Driscoll called the county CPS hotline and reported suspected child abuse. The language she used was deliberate. She described imminent danger and signs of physical abuse on multiple children. She called the parents uncooperative and possibly violent, a characterization based entirely on a brief exchange 2 weeks earlier, when Nadine had questioned why Amara had been moved to a different reading group without notice. That single conversation, a mother asking a reasonable question, became Driscoll's justification for the word aggressive in a government report. Then Driscoll made a second call. This one was to her sister-in-law, Rita Driscoll, a caseworker in the county CPS office. Text messages recovered during the investigation would later show the exchange. Janet wrote, "I need you on this one personally. The mother is difficult, very aggressive. You know the type." Rita responded within minutes. "I'll take care of it. These ones always think they're above the rules." Rita agreed to handle the case directly. No conflict of interest was disclosed. No supervisor was informed. The referral was flagged for emergency response, and 2 caseworkers were dispatched to the school before lunch. Nadine was on the bench when her personal phone vibrated in her chambers at 11:22 a.m. She ignored it. It vibrated again, then a third time. During the next recess, she checked and found a voicemail from Ms. Alicia Grant, Elijah's teacher. The message was brief, her voice low and careful. "Mrs. Coulter, I think you need to come to the school. Something is happening with your children. I can't say more right now, but please come." Nadine didn't call back. She informed her clerk, stood up from the bench mid-session, and drove to Maplewood Elementary still wearing her professional attire. She arrived at 11:40 a.m. The front office felt wrong immediately. The receptionist, who normally greeted her warmly, avoided eye contact. Another staff member turned and walked into the back hallway when she entered. Nadine said, "I'm here to pick up Elijah and Amara Coulter." The receptionist stared at her screen. "If you could just have a seat, someone will be with you shortly." Nadine did not sit. A moment later, Driscoll emerged from the hallway. Her expression was composed, rehearsed. "Mrs. Coulter, your children are being evaluated right now. You can't see them at this time." Nadine's voice was steady. "I'm their mother. Bring me my children." Driscoll folded her hands. "Ma'am, I've contacted the appropriate authorities. It's out of my hands now." "What authorities?" Driscoll paused, just slightly. "Child Protective Services. We have concerns about marks on your daughter. We have a duty to report." Nadine's expression hardened. "She fell off her bicycle on Saturday. I have photos. My husband cleaned the scrape himself. He's a surgeon." Driscoll shook her head slowly, her voice dropping into something almost patronizing. "That's what they all say." The words hung in the air, and at that exact moment, through the glass doors behind Nadine, 2 CPS workers walked into the building. The 2 CPS workers came through the front doors with the practiced efficiency of people who had done this many times before. Rita Driscoll walked in front, lanyard swinging, clipboard already open. Behind her was Tom Wilder, a junior caseworker in his late 20s who had been on the job for less than a year. Rita did not introduce herself by her full name. She did not disclose that the principal who made the referral was her sister-in-law. She looked at Nadine the way she might look at a case file, not a person. "We're here to conduct an emergency assessment regarding your children, Elijah and Amara Coulter. Based on the referral we've received, there are concerns about physical abuse. The children may need to be placed in temporary protective custody pending evaluation." Nadine's hands trembled at her sides, but her voice did not break. "You are not taking my children. I want to see the report. I want to know the specific allegations." Rita shook her head. "I'm not able to share the details of an ongoing investigation at this time." She opened her clipboard. "I'll need to ask you some questions. Do you or your husband use physical discipline in the home? Are there firearms in the residence? Has either parent struggled with substance use?" Nadine answered each question calmly, directly, and without hesitation. Then she said, "I know my rights. You cannot remove my children without a court order, unless there is immediate, verifiable danger. There is no danger. My daughter has a bruise from a bicycle fall. No one in this building even consulted the school nurse." Rita's expression didn't change. "We'll make that determination, ma'am." Behind her, Tom Wilder shifted his weight. He glanced at Nadine, then at the hallway where the children's classrooms were. He leaned toward Rita and whispered, "This doesn't seem right. There's nothing here." Rita didn't turn her head. She simply looked at him with an expression that ended the conversation before it started. Wilder stepped back and said nothing more. Rita looked at Nadine and delivered the words as though reading from a script. "We'll be taking the children for a 72-hour evaluation at a designated facility. You'll be contacted with the details." Nadine's voice was immediate. "Absolutely not. You have no court order. You have no evidence. You are not removing my children from this school." Driscoll, who had been watching from the hallway, reached for the phone on the front desk and dialed the school resource officer. "Dale, I need you in the front office. We have a situation." Officer Dale Mounier arrived within 2 minutes. He was 44, white, broad-shouldered, and carried himself with the kind of authority that expected compliance, not conversation. He had 3 excessive force complaints in his file over the past 5 years, all dismissed internally. He stepped into the office and positioned himself directly behind Nadine. Rita gestured toward the hallway. "We need the children escorted to our vehicle." Nadine turned and stood between Mounier and the corridor. Her back was straight, her feet planted. "You will not touch my children." Mounier exhaled slowly. "Ma'am, don't make this harder than it has to be." Through the glass walls of the front office, parents arriving for early pickup began to slow down. A woman stopped mid-step on the sidewalk, staring. A man in a parked car lowered his window. Phones came out. A black father named James Whitfield pushed through the front doors and stepped inside. "What's going on here? Why are you doing this to her?" Mounier pointed toward the exit. "Sir, this doesn't involve you. Step outside." Whitfield didn't move. "I'm not leaving. I'm watching." In the hallway behind Driscoll, teachers had gathered near their classroom doors. One of them, Miss Alicia Grant, the same teacher who had called Nadine, walked toward the office. Her voice was quiet but steady. "Those children are fine. I see them every single day. This is wrong." Driscoll turned sharply. "Miss Grant, return to your classroom, now." Grant held her gaze for a moment, then stepped back. But she did not stop watching. No one did. The security cameras above them recorded every frame. Mounier reached for Nadine's arm. His fingers were inches from her sleeve when she stepped back, not in panic, but with the controlled precision of someone who understood exactly what was happening and exactly what came next. She reached into her jacket, pulled out a leather credential case, and held it up at eye level. "My name is Judge Nadine Coulter. I sit on the United States District Court, Eastern District. I preside over civil rights and constitutional law cases, including cases exactly like what is happening in this room right now." The room went silent. Not quiet, silent. Rita's face drained of color, her clipboard lowered to her side. Driscoll, who had been standing near the hallway with her arms crossed, froze. Her mouth opened slightly, but nothing came out. Mounier's hand dropped to his side as though the air itself had pushed it down. Nadine held the credential steady, her voice cutting through the stillness with surgical control. "You have fabricated an emergency to remove 2 healthy, well-loved children from their mother based on a bicycle bruise. You have interrogated my 7-year-old daughter behind a closed door for 20 minutes without my knowledge or consent. You have pulled my son from his classroom and questioned him without a parent, guardian, or counselor present. You have used language in a government referral that you know to be false. And you have attempted to use a family connection inside this CPS office to fast-track an unlawful removal." She turned and looked directly at Rita. "I know who you are. I know your maiden name is Driscoll. I know the principal of this school is your sister-in-law. And I will be requesting a full conflict of interest investigation before the day is over." Tom Wilder took a visible step away from Rita. His clipboard hung at his side. He stared at the floor. Driscoll sat down slowly in the nearest chair, her face slack. James Whitfield, still standing near the door, exhaled audibly. Through the glass, 2 parents had their phones raised, recording. No one in the room moved. No one spoke. Because every person standing in that office understood that the ground beneath them had just shifted in a way none of them could undo. Nadine did not wait for anyone in that room to find their voice. She stepped into the hallway, pulled out her phone, and made 2 calls. The first was to her husband, Derek. She spoke in short, precise sentences. "I'm at the school. They tried to take the children. CPS was called on a fabricated report. I need you here." The second call was to her judicial chambers. Her law clerk, Daniel Reeves, answered on the first ring. Nadine's instructions were specific. "Contact the county CPS director immediately. Then call the State Inspector General's office. Then the U.S. Attorney's Office Civil Rights Division. I want all 3 notified within the hour." Reeves didn't ask questions. He started dialing before she hung up. Within 30 minutes, the calls had landed. The county CPS director reached Rita Driscoll on her cell phone. The conversation was brief. "You are to stand down immediately. Do not touch those children. Do not speak to the mother. A supervisor is on the way. Do not leave that building." Rita said nothing. She sat down in the front office and placed her clipboard on the desk, face down. At the same time, the school district superintendent received 4 separate calls from parents who had witnessed the scene through the glass office walls. One parent had already posted a video to social media. A local news producer received a tip from someone in the parking lot and dispatched a crew. By 2 p.m., Nadine was in the locked classroom with her children. Amara ran to her, tears streaming, and pressed her face against her mother's chest. "The lady kept asking if you hurt me, Mommy. I told her no. She kept asking." Elijah stood by the wall, arms folded, jaw tight for a 10-year-old. "I told them you didn't do anything. They didn't listen. They didn't care." Nadine held them both. She kept her voice even. She told them everything was going to be okay. She walked them through the hallway, past the silent office staff, past Driscoll's closed door, and out into the parking lot. She buckled them into the car, closed the door, sat in the driver's seat, and for the first time that day, broke down completely. The investigation moved faster than anyone at Maplewood Elementary expected. Within 48 hours, federal and state investigators had secured the school's security footage, every frame preserved and cataloged. The cameras told the story Driscoll had hoped no one would see. Amara being led down the hallway into the principal's office, her small face confused, the door closing behind her. 20 minutes later, the same door opening and Amara emerging in tears. Then Elijah, pulled from class, escorted into the same office, the same closed door. The footage showed Driscoll making 2 phone calls afterward, one to CPS and one to a personal number that records confirmed belonged to Rita Driscoll. Investigators subpoenaed the text messages between them. The exchange was devastating. Janet had written, "I need you to handle this one personally. The mother is difficult, very aggressive. You know the type." Rita's reply came 4 minutes later. "I'll take care of it. These ones always think they're above the rules." Those messages would later be read aloud in a courtroom. Driscoll's email history revealed the broader pattern. Over 6 years, she had filed 14 CPS referrals. 13 involved Black or Hispanic families. Not one was substantiated. Every case was closed without findings. The school nurse, Karen Whitley, filed a sworn statement confirming that the bruise on Amara's knee was entirely consistent with a minor fall, and that Driscoll never consulted her before making the report. Ms. Alicia Grant and 3 other teachers provided statements confirming the Coulter children were happy, well-adjusted, and showed no signs of abuse or neglect. 2 of those teachers went further. They revealed that Driscoll had pressured them on multiple occasions to document minor behavioral incidents involving minority students, things like talking out of turn or forgetting homework, while identical behavior from white students was ignored entirely. The pattern was not subtle, it was systematic, and now it was on the record. The U.S. Attorney's Office did not wait for the internal reviews to run their course. Within 2 weeks of the incident, a federal civil rights investigation was formally opened. The charges came down 1 month later. Janet Driscoll was charged with conspiracy to deprive civil rights under 18 U.S.C. Section 241, filing a false report to a government agency, and abuse of authority in connection with her role in public education. The indictment detailed not only the Coulter case, but referenced the pattern of racially targeted referrals spanning 6 years. Rita Driscoll was charged with abuse of authority, conflict of interest, and conspiracy. She was terminated from the county CPS office the same day the charges were announced. Her supervisor issued a statement confirming that Rita had never disclosed her familial relationship with the referring principal, a direct violation of agency ethics policy. Officer Dale Mounier was placed on unpaid leave pending a full investigation into his role at the school and the reopening of 3 prior excessive force complaints that had been previously dismissed. The Lake Ridge School Board convened an emergency session. Driscoll was terminated by unanimous vote. Board members who had previously dismissed complaints against her sat in silence as the security footage played on a screen in the closed session. 2 of them would later face public calls for their own resignations. Gary Driscoll, Janet's husband and sitting city council member, resigned within the week. Investigators had uncovered evidence that he had used his position to intervene with the school board on 2 prior occasions when complaints about his wife were escalating. His resignation letter cited personal reasons. No one believed it. Tom Wilder, the junior CPS caseworker who had whispered, "This doesn't seem right," in the school office that day, cooperated fully with federal investigators. He was not charged. His testimony detailed how Rita had directed him to bypass standard intake protocols, skip the supervisory review, and move directly to emergency removal without sufficient evidence. He said he had objected quietly, and she had shut him down. His cooperation would become a critical piece of the prosecution's case. The federal trial opened on a Monday morning in a packed courtroom. The gallery was full. Journalists lined the back row. Civil rights attorneys sat behind the prosecution. Families who had been targeted by Driscoll over the years filled the remaining seats, some of them seeing each other for the first time, realizing they were not alone. Prosecutors built their case methodically. First came the security footage from Maplewood Elementary, played on courtroom monitors in unbroken sequence. The jury watched Amara being led down the hallway, her small hand at her side, her face uncertain. They watched the office door close. They watched it stay closed for 20 minutes. When the audio from the interior camera was played, enhanced and transcribed for clarity, the courtroom heard a 7-year-old girl say, "My mommy didn't hurt me," over and over, while an adult voice continued pressing. Several jurors looked away. One wiped her eyes. Then came the text messages. Prosecutors displayed them on screen, one after another. "I need you to handle this one personally. You know the type. These ones always think they're above the rules." Then, the email. "Some families just don't belong in a school like this." Then, the referral history. 14 reports, 13 against families of color, 0 substantiated. Driscoll's defense argued she had acted in good faith, exercising her duty to protect children. The prosecution dismantled it in hours, showing she never consulted the school nurse, never contacted the mother, fabricated language in the CPS report, and coordinated a back-channel removal through a family member. Rita's defense collapsed entirely when her own text messages were read aloud a second time during cross-examination. Her attorney offered no rebuttal. Over 20 families testified about Driscoll's pattern. The jury deliberated for less than a day. Guilty on all counts for both defendants. Driscoll was sentenced to 4 years in federal prison. Rita received 2 years and 6 months. Officer Dale Mounier, tried separately, was fired and permanently decertified based on the investigation into his conduct history and his role in the attempted removal. Judge Nadine Coulter recused herself from the bench for the civil proceedings and retained private attorneys to file suit on behalf of her family. The lawsuit named the Lake Ridge School District, the county CPS office, Janet Driscoll, Rita Driscoll, and Officer Dale Mounier as defendants. The claim cited civil rights violations under federal law, unlawful interrogation of minors without parental consent, intentional infliction of emotional distress, fabrication of a government report, and systemic racial discrimination enabled by institutional negligence. The evidence made the case nearly impossible to defend. Security footage, text messages, email records, referral data, teacher testimony, and the sworn statement of the school nurse formed a record so thorough that settlement negotiations were brief. The case settled for $1.8 million. But the money was not the point. As part of the agreement, the district and county committed to sweeping structural reforms. Mandatory parental notification before any child could be questioned by school administrators about suspected abuse. Independent oversight of all CPS referrals originating from schools. Demographic auditing of referral patterns with public annual reporting. Conflict of interest screening for all CPS caseworkers assigned to school-originated cases. Mandatory implicit bias training for all school and CPS staff with quarterly assessments. The impact reached beyond the district. The state legislature, citing the Coulter case and floor debate, passed what became known as Coulter's Law, a statute requiring that all CPS emergency removal requests be reviewed and approved by an independent judicial officer before children could be separated from their parents. No more removals based on a single unverified phone call. No more back-channel coordination. No more unchecked power over families who had done nothing wrong. Nadine used a portion of the settlement to establish the Coulter Family Justice Initiative, a legal defense fund providing representation to families of color targeted by false or racially motivated CPS reports. Within its first year, the initiative took on 37 cases across 4 states. 12 resulted in formal findings of misconduct against the reporting parties. Every one of those families had been told, at some point, that the system was working as intended. 6 weeks later, on a bright Monday morning, Nadine Coulter pulled into the drop-off lane of a new school. Elijah sat in the back seat with his backpack between his knees. Amara sat beside him, her hand already reaching for the door handle. They walked in together. Elijah's shoulders were straight. Amara held her mother's hand and looked up at the building with curiosity, not fear. A teacher greeted them at the entrance with a smile. No one stopped them. No one questioned whether they belonged. No one looked at them and saw a problem to be solved. They were children walking into a school, and that was all they needed to be. Back at Maplewood Elementary, a memo circulated to all staff the following week. It was issued by the new interim principal and reviewed by the district's legal office before distribution. At the top of the page was a single still frame pulled from the school's own security footage. It showed a 7-year-old girl in a navy skirt being led down a hallway by an adult hand on her shoulder. The girl's face was turned slightly toward the camera. Her eyes were wet, her mouth was open, mid-sentence. Beneath the image were 6 words. This is what failure looks like. No names were printed. They didn't need to be. Janet Driscoll was in federal prison. Rita Driscoll was in federal prison. Dale Mounier had lost his badge, his certification, and any future in law enforcement. Gary Driscoll had resigned from the city council. The school board members who had dismissed years of complaints were facing recall campaigns. The system that had protected all of them, that had filed away grievances, buried patterns, and treated Black and Hispanic families as problems rather than people, was forced to change. Not because of outrage alone, not because of public pressure alone, but because of evidence. Because of teachers who spoke up, because of a father who refused to leave, because of security cameras that captured what was meant to stay hidden, and because the woman they tried to break happened to be someone the system could not ignore. In an interview months later, Nadine Coulter was asked what she wanted people to take from what happened. She paused, then said, "I had the power to fight back. I had the credentials, the legal knowledge, and the resources. Most Black mothers in that situation don't. They lose their children to a phone call and a lie, and no one ever corrects it. That's what has to change. Not just the laws. The assumption that we don't belong, that we don't deserve the benefit of the doubt, that our families are guilty until proven innocent. That is what has to change." This case was disturbing, but the one on the right ends in a way no one expects.
Stay down! I told you to stay down!
I am not resisting.
You walk in here dressed like that expecting everyone to salute you? I don't care how many medals you pinned on. You don't get special treatment because you throw on a uniform.
My identification is valid.
I've seen...
At 6:14 p.m. on a Sunday evening inside Atlanta Hartsfield-Jackson International Airport, a Black man in navy dress blues walked through the civilian terminal alone. His name was Senior Chief Darnell Osei. He was 38 years old, an active-duty Navy SEAL with more than 16 years in special operations. Less than 72 hours earlier, he had been emergency evacuated from a covert operation inside Iranian territory. The details of that mission would never be made public. What was visible were the marks it had left on him. A bandaged right hand, a sutured cut above his left eyebrow, eyes that hadn't closed in over 40 hours. He carried a duffel bag over one shoulder and a sealed military dossier under his arm, stamped with Department of Defense classification markings. He had been rerouted through Atlanta on a military transport connection and directed through the civilian terminal to catch a flight to Naval Station Norfolk, where a classified debrief was waiting. The terminal was busy with the usual Sunday evening crowd. Families returning from vacations, business travelers on red-eyes, flight crews moving between gates. Osei moved through them with the steady, controlled posture of a man trained to function under conditions that would break most people. His pace was even, his eyes forward, his uniform pressed despite everything he had been through. The ribbons on his chest told a story most people in that terminal couldn't begin to understand. He wasn't looking for attention. He wasn't making a scene. He was a wounded serviceman trying to get from one gate to another inside his own country. He just wanted to get to his flight. Officer Craig Bellingham stood near the international arrivals corridor with a coffee in one hand and his radio on his shoulder. He was 42 years old and had been with the Atlanta Airport Police Department for 16 years. In that time, 31 complaints had been filed against him, overwhelmingly by Black and Latino travelers. Excessive questioning, unnecessary pat-downs, aggressive detentions that led nowhere. Every single complaint had been investigated internally and cleared. Some were dismissed as misunderstandings. Others were filed away with vague notes about high-pressure situations. None of them ever stuck. Among certain colleagues, Bellingham had earned the nickname the Gatekeeper. He wore it with pride, never quite understanding the contempt behind it. His partner that evening was Officer Nolan Fitch, 29, 5 years on the job. Fitch was quieter, more cautious, and had learned early on that questioning Bellingham's instincts was not something you did twice. He stayed a step behind, watching the crowd, following Bellingham's lead without hesitation. Bellingham's eyes moved across the terminal the way they always did, scanning, sorting, deciding who belonged and who didn't. And then they locked on one traveler in particular, a black man in navy dress blues walking through the concourse with a duffel bag and a sealed envelope under his arm. Bandaged hand, cut above his eyebrow, tired eyes. Most people in that terminal would have seen a wounded serviceman coming home. Bellingham didn't. He saw a black man in a uniform that didn't sit right with him. He saw someone who didn't match his idea of what a senior chief was supposed to look like. He saw a target. And he was already moving. Bellingham stepped directly into Osei's path. The gap between them was less than 2 feet. "Hey, hold up! Where are you coming from?" Osei stopped. His posture stayed straight, his tone respectful. "Military travel, sir. I'm connecting through to Norfolk." Bellingham's eyes ran slowly over the dress blues, the ribbons, the bandaged hand, the sealed envelope under Osei's arm. He didn't step back. "You look like trouble. Where'd you get that injury?" Osei kept his voice level. "I'm returning from an overseas assignment. I have my military ID and travel orders if you'd like to verify." Bellingham held out his hand. "Let me see." Osei reached slowly into his jacket and produced his military ID and folded travel documents. Bellingham examined them the way a man examines something he's already decided is fake. He turned the ID over, looked at the photo, looked back at Osei, then shook his head. "These could be fake. Guys buy these online all the time." "They're not fake, sir. You can verify them through—" "I'll decide what I verify." Bellingham handed the ID to Fitch without looking at him. Osei's jaw tightened slightly. "I'd like to speak with a supervisor." Bellingham's expression shifted. "You don't get to make demands. Put the bags down. Both of them." Osei lowered the duffel to the floor, but he kept the sealed dossier under his arm. "Sir, this document is classified military material. I'm not authorized to surrender it to civilian law enforcement." Bellingham stepped closer. His voice dropped, but carried enough to reach the travelers who were beginning to slow down and watch. "I don't care what you call it. You put it down, or I'll put you down." Fitch shifted his weight behind them. His eyes moved to the growing number of phones being raised across the concourse. He said nothing. Osei placed nothing else on the ground. He held the dossier steady under his arm, his voice calm and clear. "This document is classified. I am not authorized to release it." That was the last full sentence he got out before Bellingham grabbed his arm. The grip was hard and immediate, fingers locking around the same wrist that was already wrapped in gauze. Osei didn't pull away. He didn't shift his weight. He said, "I am not resisting. This document is classified." Bellingham twisted the arm upward. The gauze tore slightly and Osei's jaw clenched, but he stayed still. Then Bellingham drove his open hand into Osei's upper back and shoved him forward. Osei's knees hit the tile first, then his shoulder, then the side of his face. The sealed dossier skid across the terminal floor, spinning to a stop near a row of seats. The sound of the impact echoed through the concourse. A woman gasped. A child near the window started crying. Fitch moved in fast and pinned Osei's legs to the floor. Bellingham dropped a knee between his shoulder blades and yanked both arms behind his back. The bandage on Osei's hand tore open completely. Blood smeared across the white tile. "Stop resisting!" Bellingham shouted. "I have not moved," Osei said. His cheek was pressed flat to the floor. His breathing was controlled. "You are on camera." Bellingham leaned close. The body cam on his chest was blinking red. It picked up every word. "Guys like you always have a story. Uniform doesn't make you somebody." The concourse had gone still. A wall of phones surrounded them. A retired Marine colonel in a veteran's cap stepped forward, his voice hard. "That man is in a Navy uniform. Let him go. Now." A young woman near the gate had her phone raised at arm's length, live streaming. The viewer count was already in the thousands. A white man in a business suit announced loudly, "I'm an attorney, and what I'm watching is unlawful." Fitch leaned toward Bellingham, voice low. "Craig, maybe we should check with a supervisor." Bellingham didn't look at him. He tightened the cuffs and stood up. Airport Police Sergeant Vanessa Trask came around the corner of Concourse B at a fast walk, drawn by the radio call Bellingham had put out and the sound of raised voices carrying down the terminal. She was 44 years old, 18 years on the job, and had supervised enough shifts to know the difference between a real incident and an officer making one. What she saw stopped her mid-stride. A black man in full Navy dress blues was face down on the terminal floor, blood on the tile beneath his hand, cuffs on his wrists, a knee mark still visible on the back of his jacket. Two officers standing over him, and a sealed military dossier lying 10 feet away on the ground near a row of plastic seats, classification markings facing up for anyone to see. Trask moved fast. She stepped between Bellingham and the crowd, looked down at Osei, then back at Bellingham. "Get him up. Now." Bellingham didn't move. He's non-compliant. Trask crouched slightly and picked up the military ID that Fitch was still holding. She read the name, the rank, the unit. Senior Chief Petty Officer, Naval Special Warfare. She stood slowly and looked Bellingham directly in the eyes. Her voice dropped low enough that only he and Fitch could hear. "Craig, do you have any idea what you've done?" Bellingham's jaw tightened. He was, "Take the cuffs off. Now." Bellingham didn't move. Trask didn't blink. "That was not a request, officer." Fitch stepped forward and removed the cuffs. Osei rose slowly from the tile. His right hand was bleeding freely now, the bandage torn away completely. The cut above his eyebrow had reopened. He flexed his fingers, wincing, and looked at Trask. She met his eyes. "Senior Chief, I'm Sergeant Trask. I'm calling medical and my commanding officer right now." She walked to the dossier, picked it up carefully by the edges, and secured it under her arm. Then she keyed her radio. "Chief Pratt, this is Trask, Concourse B. I need you here immediately. We have a situation involving an active duty Special Operations Service member and classified military documents." Trask walked Osei down a side corridor and into a small conference room used for internal briefings. She offered him water and a chair. He took both. His posture was still straight, but the exhaustion was pulling at him now. 40-plus hours without sleep, a reopened wound, and the adrenaline beginning to drain from his system. Airport Chief Julius Pratt arrived within minutes. He was in his late 50s, calm, deliberate, and the moment he stepped into the room and saw the classification markings on the sealed dossier, his expression changed. He picked up the phone and dialed the Department of Defense liaison number. The call lasted less than 3 minutes. His voice was tight the entire time. "Yes, sir. Active duty. Naval Special Warfare. Classified material was on the floor of a public terminal. Bodycam was rolling." He hung up and looked at Trask. Within 20 minutes, 2 men in civilian suits walked through the terminal without stopping at any checkpoint. One was from NCIS. The other carried credentials from the Defense Intelligence Agency. They secured the dossier first. Then they asked to see the bodycam footage. The playback began in a closed room down the hall. It showed everything. The unprovoked stop, the profiling language, the refusal to accept valid military identification, the grab, the twist, the shove, the sound of Osei's body hitting the floor, the blood, the knee, and then the voice, clear and unmistakable. "Guys like you always have a story. Uniform doesn't make you somebody." It also showed the classified dossier skidding across a public terminal floor, visible to every camera and phone in the concourse. A potential intelligence breach caused entirely by one officer's decision to put a decorated serviceman on the ground. The DIA officer stepped out of the room and made a single phone call. His voice was flat. "We have a compromised asset situation and an assault on an active operator. Initiate federal jurisdiction." He hung up and walked back inside. Pratt looked at Trask. "Pull Bellingham and Fitch off duty immediately. Radios, weapons, badges, body cams, everything." The NCIS agent added without looking up from the screen, "And nobody talks to them before we do." A federal attorney reviewing the footage in Washington that same hour said it plainly. "This isn't misconduct. This is a federal crime on at least 4 counts." By the time the sun set over Atlanta that evening, the live stream from the terminal had crossed 2 million views and was still climbing. The young woman who had started recording near the gate had not stopped. Her footage showed everything from a civilian angle: the shove, the blood, the cuffs, the crowd's reaction, and the moment Trask arrived and shut it down. News outlets began calling the airport's communications office before the bodycam footage had even finished its first internal review. Local affiliates ran the story at 10. Cable networks picked it up by midnight. By morning, it was national. The Pentagon released a formal statement within hours. It was unusually fast and unusually blunt. An active-duty senior chief petty officer returning from a classified overseas operation was subjected to racially motivated assault by civilian law enforcement. The Department of Defense is cooperating fully with federal authorities and will ensure full accountability. In Washington, behind closed doors, the language was not diplomatic. A senior defense official stood before a room of JAG attorneys and investigators and said what the press release could not. He was evacuated under fire from a hostile nation. He survived what most people in this building will never have to face. And then he got his face put on the floor of an American airport because of the color of his skin. This ends careers. This ends freedom. There was no discussion after that, only action. The Department of Justice Civil Rights Division opened a formal investigation. Homeland Security's Office of Inspector General launched a parallel inquiry into airport police operations at Hartsfield-Jackson. NCIS formally assumed control of the criminal investigation, pulling jurisdiction from local authorities entirely. That same night, Senior Chief Darnell Osei sat in a quiet room at the airport and gave his full statement to a federal agent. His voice was steady. His recollection was precise. He described every word Bellingham had said, every point of physical contact, every second of the encounter, from the first step to the last cuff. The agent listened without interrupting. When Osei finished, the agent closed his notebook and said, "That's one of the clearest statements I've ever taken." Osei nodded once. "I was trained to remember details under pressure." Officer Craig Bellingham was placed on unpaid suspension the following morning. His badge was collected, his firearm was secured, his access card was deactivated. He was told not to contact any member of the department or any party involved in the investigation. He drove home in silence. Within 48 hours, his 31 prior complaints were pulled from internal files and placed under federal review. What the department had spent 14 years dismissing, the federal government began examining in detail. And then, the victims started coming forward. A black airline pilot named Captain Solomon Ibarra was the first to speak publicly. He described being stopped by Bellingham 2 years earlier while walking through the terminal in full uniform with his crew. Bellingham had detained him for 45 minutes, questioning whether his credentials were real, refusing to contact the airline for verification, and only releasing him after a gate supervisor intervened. Ibarra said he had filed a complaint. It was marked resolved, with no action taken. A Latino TSA supervisor named Hector Padilla came forward next. He described being accused by Bellingham of trespassing inside the terminal where he had worked for 9 years. Bellingham had demanded his employee badge, called it suspicious, and threatened to have him escorted out. Padilla had filed a formal grievance. It disappeared into the same internal system that had swallowed every other complaint. Then came a black mother named Simone Achebe. She had been traveling alone with her 8-month-old son when Bellingham pulled her aside for a random search. The search lasted over 30 minutes. She missed her flight. Her infant screamed the entire time. She said Bellingham told her that if she had nothing to hide, she wouldn't be so upset. She filed a complaint through the airport's public liaison office. She never received a response. 14 victims in total came forward within the first 2 weeks. Each story followed the same pattern. A person of color stopped without cause, a fabricated justification, an aggressive encounter, a complaint filed and buried. Internal emails surfaced during the federal review that confirmed what every victim already knew. Supervisors were aware. One email from a lieutenant sent 3 years earlier read plainly, "Bellingham's numbers are high, but he keeps the terminal clean. Let it go." That email would become the centerpiece of the federal investigation, not because of what it said about Bellingham, but because of what it proved about the department. They knew. They always knew. And they chose to look the other way. Craig Bellingham sat in his living room under the terms of his suspension. The television was on. His name was at the bottom of the screen. It had been there every day for weeks. His wife had stopped answering the phone. His former colleagues had distanced themselves completely. The union that had backed him through 31 complaints over 14 years had gone silent. No statement, no legal fund, nothing. Every day new coverage surfaced. Another prior victim interview. Another legal expert breaking down the Bodycam footage frame by frame. Another segment about the classified dossier that slid across a public terminal floor because one officer decided a black man in dress blues didn't look right. Outside the federal courthouse, protesters gathered with enlarged stills from the Bodycam footage. Bellingham's knee on Osei's back. The blood on the tile. The dossier on the ground with classification markings visible. Inside, attorneys prepared for what analysts were calling one of the most clear-cut federal civil rights cases in recent memory. The Pentagon had not withdrawn its statement. Federal monitors were already assigned to the airport police department before a verdict had been reached. Osei had not spoken publicly since his statement to NCIS. He had returned to limited duty at Naval Special Warfare Command. His commanding officer had made clear the Navy considered the matter far from resolved. The Bodycam footage had crossed 30 million views. It had been entered into federal evidence. It would be played in a courtroom. Every frame, every word, every second of a decorated Navy SEAL's face pressed to the floor of an American airport while bleeding from wounds he received serving his country. And somewhere between a federal investigation and charges that could reach 20 years, a man who survived extraction from hostile territory in Iran sat in uniform, waiting for a system that failed him on a terminal floor to decide whether it would fail him again. The cameras were still rolling. The world was still watching. And this story was not over. If this story moved you, don't just watch in silence. This case was disturbing, but the one on the right ends in a way no one expects.